Hey everyone, this is the module on harassment, bullying, and abuse. And this module covers a lot of ground. I want to get right into it. Now, two of these areas are very tightly related, and then the child abuse issue sort of tags on at the end. Let's get started with the problem that we are all having so profoundly in schools these days, and that's this challenge of cyberbullying. Of course, these days the form mostly takes smartphones and not computers, but still, this is the primary challenge that a lot of school leaders are really trying to cope with in schooling. And as we talk about this challenge, I really want to legally frame this challenge for you and sort of use this as the primary way to help work our way through the data set. All right, so when it comes to bullying in the United States, nearly all states, Montana was sort of the last one coming through, have had some policies that have addressed bullying both at the state level and the local level. And a lot of times what the state level does is try to force the local level to do something. So we have just this massive proliferation over the last decade of anti-bullying laws across the United States. And so there's this sort of question of what does all this law do? We have, in Kentucky, of course, is a state that has a A+ rated anti-bullying law on the books. What does it do? And the answer is nothing. Well, let me put a mostly around that. What the laws all do, for the most part, is force local bodies, like a local school district, to adopt policy prohibiting bullying. All right. Now, bullying is a concept that has for a long time been prohibited in schooling. You know, this is not something that educators have supported for the first century of schooling, and now suddenly we're deciding that we're not going to support this. It's something we've always been regulating, and so as these new policies have come in, what you've seen a lot of these new policies, including this one that's very prolific in Kentucky, it's get used over and over and over again, is that when they define bullying, they wind up defining bullying in using a lot of other terms. So here, name-calling, teasing, threatening, social exclusion, cyberbullying. It might be verbal, emotional, sexual in nature. Super wide-ranging sort of definitions of bullying, but using a lot of terminology that we've already prohibited. When you look at this section on actions not tolerated, for instance, in most state policy across Kentucky and local school district level, the use of lewd, profane, and vulgar language is prohibited. Well, you know, with our First Amendment law, we already prohibit all of that. Things that schools could regulate under the Constitution. And so, you know, bullying is an important area. It's one that you as school leaders should absolutely seek to limit as much as possible. But bullying represents something that struggles to be legal in nature. It's really something that's quite normative in nature. And when you see the name-calling, teasing, threatening, social exclusion going on in your schools, it's something that you should regulate. However, from a legal standpoint, the law is going to stay pretty far out of that. Now, on the other hand, let's talk about harassment. And now harassment is something that, honestly, this is huge in schools. So we have some clear law, mostly under Title IX, that has prohibited student-to-student harassment. And I'm going to get back to that in just a minute, and because that gets us really close back to that bullying space. But before I sort of deal with the Title IX student-to-student issues, let's talk about sort of the Title VII, more workplace-oriented issues that revolve around sort of teacher-driven harassment, both of other teachers and of students. So when it comes to the teacher issues, employer to employee, Title VII sort of prohibits two different kinds of harassment in that context. The quid pro quo harassment, that is, you know, you do something for something else. You know, like you maintain a relationship with a supervisor in exchange for getting promoted into some other thing. That's a quid pro quo harassment and clearly prohibited. And then the other kind of clearly prohibited harassment that we have at the employer-to-employee level is around hostile work environment harassment, where the work environment that an employee is asked to participate in is just hostile to a particular gender that really makes things difficult to work there. This could also be potentially on sexual orientation grounds or any other form of potential harassment. There might be a hostile work environment, and that, of course, can be used to work in this area as a legal claim. I want to throw down there at the bottom, there is a statute on abuse of teachers. Does not get used very often when it comes to sort of outsiders of the, so like members of the public abusing teachers. Very, very rarely used, but if you're really dealing with this challenge in your particular school, you might look at that statute. More common in schools is employee to student harassment. Now we are starting to get into Title IX issues. What Title IX has shaped up employee to student harassment. It's created a quite easy legal test for students to prove. So it's really wanting students to bring these claims against potential employees that are harassing them. It asks only that school officials have actual knowledge of the harassment and deliberate indifference. All right, so these two components, actual knowledge, deliberate indifference, and then we can have a Title IX claim against a school district for employee to student harassment. And there's quite a bit of litigation going on in this space these days between students and employees. School districts have deep pockets, and so as your employees are harassing kids, that's creating a lot of legal liability, and kids are having a lot of success on those claims. Now, when it comes to matters of any type of sexual relationship between employees and kids, of course, it's absolutely all prohibited. There's actually a long list of things that legally are wrong with this, and that will sort of happen legally as a result, including losing licenses and potential criminal actions against teachers, of course. And then there's a lot of potential liability for school officials that knew about this kind of relationship and then didn't do anything about it. You potentially could also lose your license as a school leader. All right, now let's jump all the way over to the student side under the Title IX. So up there at the top where you see the student box. Now we're going to stay completely under Title IX. We've already sort of dealt with the school personnel issue under Gebster versus Lago Vista. Now we're going to turn our attention to the Davis standard, that is kid-to-kid, student-to-student harassment. So again, we're still under Title IX as the operative large federal law that's giving rise to all these claims. And on the student-to-student harassment side, what the courts have said is that with three criteria, if three criteria are present, we will find against the school for student-to-student harassment that was not corrected by school officials. All right, so those three are the first two coming from employer-to-student harassment, so actual knowledge and deliberate indifference. And then you add on persistent, severe, and objectionably offensive. All right, what we're adding on that third component there, because trying to regulate every single component of student-to-student harassment in schools is just a completely difficult task. So when you have actual knowledge and you are deliberately indifferent to harassment from kid to kid that is persistent and severe and offensive, that is when you, as a school official, might be in trouble both yourself and for the school, right? So that three-part test is the legal standard. It's a huge legal standard. It's getting used a ton in schools. So let me give you an example. So here's a case that came out of Connecticut about a decade ago, and this particular case was around cell phones, the kind of questions and problems that we have. Of course, then we were dealing with BlackBerries, not dealing with iPhones, right? The iPhone cases are just now all making it to the courts. Male student harassing a female student on phone, police notified. The students were still interacting at school. Even though the school officials sort of had notice of this difficult relationship between the male student and the female student that started on digital spaces and merged into physical spaces, the school didn't stop it. It then went on to, the kid got arrested, but the kid's friends all intervened and started sending harassing voicemails on the phone to the kid. And at this point, we've got quite a bit of harassment going on. The student was forced to withdraw from the school, and then, of course, the student's family sues the school, right? So that's the series of facts that gave rise to a result where the Title IX claim is going to survive summary judgment and we're going to have findings of fact against the school on the Title IX claim. Now, cases like this, once they survive summary judgment, almost always wind up settling, right? The school district's going to pay a lot of money for this to go away. Now, that's not a good result from the school leader's standpoint, right? That's something the school board is going to have to deal with, and the school board having to deal with such large settlements does not reflect well on the school leaders at those schools. Okay, so that's how a harassment case plays out in digital cyberbullying spaces. What you're really looking for are those three criteria from a legal standpoint only: deliberate indifference, actual knowledge of the harassment, and then sort of a severe, pervasive, and ongoing offensive nature of that type of harassment. When those three things are present, legal consequences might ensue. But for you all as school leaders, the smartest thing to do before we get to child abuse, smartest thing is don't be deliberately indifferent. Get involved. Intervene when you see bullying or harassment going on in your schools. What the law is saying is when you get involved, we will protect you. We want you to be active. Even if your actions don't cure the bullying or the harassment, okay, we want you to be active, and so we're going to structure the law to make sure that you're being really active in trying to regulate bullying. Quickly on to child abuse. Child abuse is something that came up in your pre-service programs. I know it gets talked about a lot in schools. You get tons of PD in schools around it. So I'm just going to bring up some of the basics here. We have sort of a clear child abuse statute. It creates three different areas of abused or neglected children. You need to sort of be aware of all these potential types of abuse that are functioning in your schools: the physical abuse, the emotional abuse, sexual abuse. I'm not an expert on abuse. I'm just letting you know that legally there's these three different big areas that you need to be paying attention to. Then sort of there's a lot of penalties in the law for failing to report. Again, the law is structured to make you active, to try to force you to report, to take an action. So when you don't take an action, all these potential penalties for failure to report kick in. Teachers, of course, are mandatory reporters. We're going to protect the identity of the reporter, except under potential in a court-ordered kind of situation where you have to get involved. There's a lot of concern in the law around knowingly false reporting, and I'll come back to that in a second. And then there is a misdemeanor for failing to report for you as educators. Any person that intentionally fails to report, knows of potential abuse, fails to report, that is a misdemeanor. So there's actual criminal charges that might be brought against you as a mandatory reporter of child abuse. Finally, if you use child abuse as a weapon, the law really gets ticked off at that. And so any person that knowingly makes false reports and does so with malice to try to harm a parent, that is a more serious crime. And that's the kind of stuff where you're probably going to lose a teaching license, that kind of stuff. So all of this, of course, is geared to get you to report as a mandatory reporter. Okay? We'll talk a lot about this when we get back in class together.